Welcome to another video with Pratham Test Prep. I hope everybody is doing great. Please hit on the like, share and subscribe button, and also don't forget to hit on the bell icon for regular updates. So the first thing that comes to our mind when we are discussing about our channel is that you can join our Telegram channel for all the regular updates from expert mentors, and also all the new quizzes and deadlines that are coming for colleges and their forms will be updated on this channel itself. So a new news that we have received is that National Law University is being started in Tripura, right? So this is a new university that has been established by an Act of 3 of 2022 of the Tripura legislature, and it is a premier law school that will be situated in the capital city of Agartala. Now these universities are applying and will take online applications and will accept CLAT score, and will be providing a 5-year LLB program and an LLM program in their university. So this is a new update. As you are all preparing for law, you should know what are the new NLUs that have been added to the list. Now, what is the eligibility criteria? So the eligibility criteria is that you should have passed your 10 plus 2, or you are an equivalent of 45% marks. In the case of SCs and STs, it is kept to 40%, and they will take a valid CLAT score in this also. Now, the next is that what is the courses on offer. Here we have BA LLB Honors, that is the 5-year integrated program for law that is on offer here. Now, number of seats that you will have will be 60 in this scenario. The reservation to SCs and STs shall be as per the Tripura government, and 2.5% seats shall be reserved horizontally for the specially abled persons, right? That is called the SAP. Now, coming to the next part is that what is our first news for the day. So this was a basic information to all of you, that all of you who are preparing for CLAT, now there is another NLU that has joined the list. So do make sure that you guys are looking for it, and also making sure that you collect some reviews about it also, right? So that is something that you need to keep in mind. Now, what is the first news on the day? That the Supreme Court has put on a split verdict on the Karnataka's hijab ban, right? So there was a news that we have received very recently regarding the hijab ban that happened in the state of Karnataka. So the Supreme Court has given its split verdict. So the delivery of the split verdicts on the pleas contesting the Karnataka High Court refusal to lift hijab ban on educational institutions in Karnataka, right? So that is what the Supreme Court has delivered right now. The next thing that comes up is that the Karnataka High Court held that wearing hijab is not a part of the essentials religious practice in Islamic faith, right? So it was a direct hit that the Karnataka High Court has given, and they said that it is not an essential religious practice in the Islamic faith. Now, the Supreme Court, that were consisting of Justice Hemant Gupta and Justice Sudhanshu Dhulia, heard the verdict and on challenging this verdict, right? So they were the bench of Supreme Court who were hearing the plea that was challenged in front of them, that was of the High Court order, right? They were hearing to that plea. Now, while Hemant Gupta dismissed appeals challenging the High Court's judgment, Sudhanshu Dhulia held that there shall be no restriction on wearing hijab anywhere in schools or colleges in Karnataka. So there was no clear stand that was provided by the Supreme Court on this scenario. Now, Justice Hemant Gupta said that wearing hijab is not an essential religious practice, unlike the kripan worn by the Sikhs. He also held that Karnataka government's hijab promotes environment and also favoring equality. He adjudged the permitted girls to wear hijab is an atheistic to secularism. That's what he's saying. Now, Justice Dhulia countered the ruling of the Karnataka High Court by saying that hijab ban is an invasion of privacy and dignity, and that it has to go against the right guaranteed under Article 19(1)(a), that is religion to freedom of speech and expression, and Article 21 of the Indian Constitution, that's also protecting the life and personal liberty. So you can basically saying that you can choose to wear hijab or not to wear hijab, that should be something completely your choice, and a government cannot put any restrictions on your right to profess freedom, speech, expression, protection of life and personal liberty, right? So a government cannot curtail you with your rights. That's what he is saying here. Now, coming to the next point, he held that while wearing hijab may not be an essential religious practice, but it is still a matter of choice, conscious belief, and expression. So he's saying that a person might choose not to, but a person can choose to wear the hijab, and it is a complete matter of choice, conscious belief, and expression. That's what Justice Hemant Dhulia is saying. Now, he also held that hijab ban could result in girls from conservative Muslim families being denied of education. Right? That might happen. He's saying there is a very fair chance that the people will stop letting their women child go outside and study because they are not covering their head. That can be a case. He is fearing that. Now, Justice Dhulia also questioned how wearing hijab in a classroom goes against public order, morality, or health, or against the fundamental right of the Constitution. So that's what he is questioning in this scenario. Now, what is a split verdict? We read that the Supreme Court has given a split verdict. Now, what do you mean by this term, split verdict? Now, a split verdict only occurs when a bench is unable to give a conclusive judgment, either through unanimous decision or by majority verdict. It happens only when there is an even number of judges, like division bench, two judges bench. If a split verdict occurs, the case will be heard by a large bench again, right? So there will be a 5-judge bench that would sit after this, and they will decide on the case, right? That the 2-judge bench was not able to give us a verdict that was conclusive in nature. Then there will be a bigger judge bench that would sit to give the decision in this case. So that is what is split verdict is. Now, coming to the next scenario for today is that abatement to suicide. Acts of the accused must be proximate to the occurrence for conviction under 306 of the IPC. Now, there is a very deep meaning that is being hidden in these two lines, right? We will read up all about it, but this is definitely something that the Supreme Court has said. The first thing is that the Supreme Court reiterated that positive action proximate to the time of suicide on the part of the accused which led or compelled the deceased to commit suicide should be established for conviction under 306. That means that first of all, that if a person is committing suicide and a person is being arrested because he has abetted the person to commit suicide, there has to be a positive action proximate to the time of suicide on the part of the accused, right? कि उनका ऐसा कोई एक्शन proximate था उसके आसपास की उनकी वजह से उस इंसान ने अपनी जान ली, right? Which led or compelled the deceased to commit suicide should be established for the conviction. So ये सब आपको establish करना पड़ेगा केस में under section 306 of the Indian Penal Code for a conviction under this section, right? So that's what the Supreme Court has said here. Now, in the case of alleged abatement of suicide, there must be a proof of direct or indirect acts of incitements to the commission of suicide, right? That is what the Justice M.R. Shah and Krishna Murari has observed, right? That a person, right, who is alleged of abatement of suicide, okay, there should be a direct, either the person is harassing them, sexually molesting them, doing something that is direct in nature, or they are doing something indirect in nature, right, that incites them to go and commit suicide, right? That's what, there must be a proof, okay, regarding the same. Now, the prosecution has to establish beyond a reasonable doubt that the deceased committed suicide and the appellant number 1 abetted the commission of the suicide of the deceased, right? So there has to be a direct proof that has to be put in front of the court that there is this correlation which draws towards the conclusion that this person has committed this act which has led to the death of this person beyond reasonable doubt that the court cannot think of anyone else who would have done it, right? So that's what is being said in this third point here. Now coming to the fourth point, the court has time and again reiterated that before conviction and accused under section 306 of the IPC, the court must culturally examine the facts and circumstances of the case. They should see what are the facts in the case, what are the circumstances in the person that was found dead, and also assess the evidences that were adduced before it in order to find out whether cruelty and harassment meted out to victim and had left the victim with no other alternative but to put an end to her life, right? So they have to examine all of these evidences to understand, was there any cruelty or harassment which led to the victim taking her life, okay, which she had no other alternative to go for. Now, it was also borne in the mind that in cases of alleged abatement of suicide, there must be a proof of direct or indirect incitement. Merely on the allegation of harassment, right? There is a allegation that this person has committed harassment without there being any positive action proximate. That means that there should be a connection that has to be drawn between the action and what is being claimed to that time of occurrence on the part of the accused, ठीक है, जिस time पे ये act हुआ, which led or compelled the person to commit suicide, right? In conviction in terms of section 306 of IPC is not sustainable, right? जहाँ पे ये आप proof नहीं कर पाए that there is a positive action proximate to the time of occurrence on the part of the accused, अगर ये चीज prove नहीं हुई, that means that this suit will not be sustainable in the court. So that's what the court has also said. Now, regarding the charges that were under 498 of the IPC, the bench noted except the statement of the prosecution witness recording after the incident, there is no evidence to establish that alleging of any demand of dowry or ill treatment meted out to be deceased during her marriage, right? So that's what the court is saying कि ऐसा कोई dowry death का ये case नहीं लग रहा है, right? Because there is no evidence that has been established, so the charges is not going to be taken up by the court, okay? Now, what is section 306 of the IPC where the person is being charged? It is called abatement of suicide. Now, if a person commits suicide, ठीक है, whoever abets the commission, that means uksana, किसी को मरने के लिए उकसाना, right? Whoever abets the commission of such suicide shall be punished with imprisonment of either description for a term which may extend to 10 years or shall be liable to fine or both, right? So IPC is Indian Penal Code, जहाँ पे बोला अगर किसी को आपने मरने के लिए उकसाया, then you will be held liable for that, right? So that's what is called abatement of suicide. Now coming to the next point is that mere abusive and humiliating words cannot attract offense under 294B, right? So that's what the Supreme Court has said. Now this is a case that is named as MS Madan Gopal versus K. Lalitha. Okay, this is the name of the case. You need not remember the name of the case, but it is just for your knowledge, and also if you will go in the law school also you will read a lot of cases like that. So it's better you get into the habit of reading these cases right now. Now, observing that in the overall view of the case, we are convinced that no case is made out of against the appellants here as alleged by the complainant. That's what the court has said while quashing the proceedings against the appellant. Now, the Supreme Court of India held that the abusive, humiliation or defamatory words by itself cannot attract an offense under section 294B of the Indian Penal Code of 1860. ओके कि अगर आपने सिर्फ गाली दे दिया, डिफेम कर दिया, डिफेमेटरी वर्ड्स बोल दिए किसी को, तो ये नहीं अट्रैक्ट करता सेक्शन 294B. हम उसके बारे में भी बात करेंगे व्हाट इज 294B एग्जैक्टली सेइंग, बट it does not attract any offense under this section. That's what the court has said in this case. Now, Justice S. Abdul Nazir and J.B. Pardiwala, Justice J.B. Pardiwala, heard an appeal, right, against the judgment of the Madras High Court, whereby the petition under section 282 of the CRPC was rejected. Okay. Now, The allegation against the accused appellant were that he used certain unparliamentary words, right? That was the allegation that was put against the accused. Now coming to the next part is that what is section 294 of the IPC all about, right? So the first thing is obscene acts and songs. Whoever to the announcements of allowance of others does an obscene act in public place, songs or recites or utters obscene songs, anything, right, will be punished. The court also noted that the test of obscenity under section 294B of the Indian Penal Code is whether the tendency of the mind of the matter change and obscenity is to be depraved and corrupt those whose minds are open to such immoral influences, right? So इसके अंदर उन्होंने बोला कि टेस्ट क्या है कि आईपीसी वेदर द टेंडेंसी ऑफ द मैटर चार्ज एट ऑब्सिनिटी, जिसको चार्ज किया जिस मैटर को, is to deprave and corrupt those whose minds are open to such moral influences, right? The court observed that अगर आपको अपना ऑफेंस प्रूव करना है अंडर सेक्शन 294 ऑफ द आईपीसी, ठीक है, तो अगर आपने सिर्फ खराब वर्ड्स बोले हैं ये सफिशिएंट नहीं है. देयर शुड बी अ फर्दर प्रूफ दैट इट वाज द अनाउंस ऑफ द अदर्स व्हिच इज लैकिंग इन द अबव केस. ठीक है, नो वन हैज स्पोकन अबाउट द ऑब्सीन वर्ड्स दैट they felt annoyed and in the absence of legal evidence to show that the word that were uttered by the appellants accused annoyed others, it cannot be said that the ingredients of the offense of section 294B of the IPC is made out. उन्होंने बोला कि हमें ऐसा देख के कुछ लग नहीं रहा है कि यहाँ पे कोई अनाउंस हुई है किसी की और कोई लीगल एविडेंस नहीं है, इसलिए उस क्राइम को 294B के अंदर नहीं पुश किया जा सकता. That's what the court has said. Now, the court also stated that arguments made in the complaint were not sufficient to even constitute the offense of wrongful restraint. मतलब wrongful restraint मतलब किसी को किसी जगह जाने से एकदम रोक देना. There is a wrongful confinement is that when you close someone in a room is called wrongful confinement. But if you stop someone from going in a certain direction and they have other resort available to go, right, then it is called wrongful restraint. Okay, that's what is the difference. Now, the writ of quo warranto can be issued where an appointment has not been made in accordance of law, right? So that's what the Supreme Court has said. Now, this is the case of State of West Bengal versus Anadya Sundar Das. That's the name of the case. Now, the Supreme Court observed that the quo warranto cannot be issued where an appointment has not been made with the accordance of law, right? The court observed that the writ of quo warranto can be issued, ठीक है, जहां पे अपॉइंटमेंट नहीं हुआ जैसा लॉ के थ्रू होना चाहिए था, right? The bench of Justice D.Y. Chandrachud and Hema Kohli observed while dismissing the appeals that were filed by the state of West Bengal and Sonali Chakravarti Banerjee challenging the orders of the Calcutta High Court. Now, which set aside the decision of the state to appoint Ms. Banerjee as the Vice Chancellor of the Calcutta University, right? That's what is being said here. Now, coming to the next part is that the High Court had allowed the writ petition filed by Anadya Sundar Das, an alumnus of the Calcutta High Court and a practicing advocate, seeking a writ of quo warranto against the Vice Chancellor of the Calcutta University that they have not been appointed in accordance with the law and hence there has to be a writ of quo warranto that needs to be issued on them, right? Now the next part that comes in is that the apex court bench observed that the state of West Bengal usurped the power of the councillor while reappointing Ms. Banerjee as the Vice Chancellor of the Calcutta University. That's what the court has said here. Now the bench noted that the High Court has observed that the writ of quo warranto can be issued at two places. First, when a person holding public office lacks the eligibility criteria prescribed for such appointment. That means that अगर वो बंदा eligible ही नहीं है उस appointment के अंदर, that means that he is not eligible for such appointment. The appointment is made contrary to the statutory provisions or rules, right? So that means that the जो उनका appointment हुआ है वो rules और statutory provisions के against में हुआ है. The court therefore dealt with the procedural objection regarding the limits of the quo warranto, right? That's what the court has said. Now the next is that they were referring to some other cases that were there, that is Bharti Reddy versus State of Karnataka, where they said that through these decisions, the court has settled the position that quo warranto can be issued where an appointment has not been made in accordance with law, right? So that's what the court is saying. So this is it for today, guys. I hope you were able to get a lot of information about the legal cases that have happened in the week and some more information about national law universities, new NLU that has come up, and also something about the split verdict that we discussed today. So this would be the last session before Diwali we have. So wishing you all a very, very happy and prosperous Diwali. So do make sure that you are enjoying with your friends and family and you are taking care of yourself and you are having a happy and healthy year ahead. So thank you for joining this live session. Do take care of yourself and have an amazing festive time ahead. Thank you, guys.